Good morning, everyone, and welcome to Coffee Talk. My name is Catherine Frelick, and I am delighted to be kicking off our Back to Basics series. With the pandemic, I know many organizations have felt very overwhelmed with dealing with the changing crisis from day to day. And so now we're going to go back and do some of the fundamentals, starting off with our first presentation on patient safety, quality, and risk, getting the balance right. There are a number of individuals on the line, so I would ask if you could kindly keep your lines on mute. If you have any questions, please use the chat button or box and type in your question, and I will be responding to those at the end of the presentation. So without further ado, we will start. So what are we talking about today? We're going to start with a bit of a discussion around the evolving quality landscape and the trends towards openness and transparency in the provision of healthcare. We'll talk about some of the legislation that is applicable to the sector, protecting quality and risk documentation, and then finally we'll talk about some risk management considerations that you can have in mind when you are documenting your risk and quality activities. When we start at the very fundamentals, I think it's always important to start at the top and what the responsibilities are at the corporate level. And for boards of directors, there is a corporate responsibility to ensure that there are reasonable policies and a safe environment. There's a responsibility for overall quality of care, legislative compliance, as well as the performance of the senior team. And we really focus on what I call systems responsibilities. So systems are the policies and procedures and processes you have in place, or your organizational structures and accountabilities, and ensuring that while management is dealing with the day-to-day management of the organization, the board has a responsibility to ensure that there are systems in place that are appropriate. There are continuous quality management requirements under a number of different statutes. So under the Public Hospitals Act and Regulation 965, and the different committee structure, various committee structures that are designed to address quality of care. The Fixing Long-Term Care Act recently came into force, replacing the Long-Term Care Homes Act. And one of the new sets of amendments relate to continuous quality management and ensuring that there are programs in place for every home to address those important issues. And then another example is in the Home and Community Care Services Regulation under the Connecting Care Act, which continues obligations for home and community care service providers to have a quality of care system in place. One of the key requirements under the Public Hospitals Act relates to critical incident reporting. A critical incident is defined under the legislation. It means any unintended event that occurs when a patient receives treatment in a hospital that results in death or serious disability, injury, or harm to the patient, and does not result primarily from the patient's underlying medical condition or from a known risk inherent in providing the treatment. So it's not every situation where there's a death. It's where there's something unexpected or unintended, an event, or it could be, there's different terminology for it, whether it's a patient safety incident or an adverse event. But there are requirements for public hospitals to ensure mandatory disclosure of critical incidents. Critical incidents are a subset of adverse events or patient safety incidents. So even if you are not required by statute to deal with critical incident reviews and disclosure of harm, it is an industry standard that is something that every organization should have in place, and it's a legal requirement for health professionals as well. So for public hospitals, when we're dealing with critical incidents, again, the board is responsible for having a system in place to ensure that every critical incident is reviewed by an appointed committee. And I'm going to underline the word committee for now and can go back to it a little bit later. A disclosure must take place as soon as practicable. And that's to either the patient or their substitute decision maker, but also to the administrator of the hospital and the medical advisory committee. And then finally, an analysis of the incident and the development of a plan with systemic steps to avoid or reduce the risk of further critical incidents is another requirement. And this is really what, the key exercise when you're reviewing a critical incident, because you are looking for learnings from a quality of care perspective that you can apply not only in this case, but in other cases as well. So back to the increased focus on accountability and transparency. Over the last number of years, there have been a number of different pieces of legislation which have promoted those concepts. The Excellent Care for All Act, the broader Public Sector Accountability Act, Connecting Care Act. We're going to focus on some of these in particular, including the Freedom of Information and Protection of Privacy Act, the Personal Health Information Protection Act, and the Quality of Care Information Protection Act. In addition to legislation, there are also many different operational mechanisms that the ministry uses to ensure accountability, including service accountability agreements, attestations, and there seem to be more and more attestations all the time on various issues, as well as ministry policies and program requirements. With all of this accountability, there are also different mechanisms where individuals and the public are able to access documents. And there's access under PHIPA, which will be applicable to every health service provider. There's public reporting, some mandatory requirements. There's public documents that you provide on a voluntary basis. If you're involved in a legal proceeding, there are production obligations that you may have to comply with, or and when I'm talking about legal proceedings, not just litigation, but also health professional regulatory proceedings. There may be coroner's inquests, any type of proceeding. And for some organizations, with the extension of FIPA to broader public sector organizations, there may also be access rights under FIPA. And so that would apply to hospitals, home and community care support services, and municipal long-term care homes. the right to access under FIPPA creates a general right of access to records in the custody or control of the institution. And the general premise is that information should be made available to the public, except in limited situations. And there are exemptions under the legislation that are quite specific. There is also a very broad definition of record. So when we're talking about records, we're talking about any format. It includes emails, text messages, video recordings, or any other record that is in the custody or control of the organization. Similarly, under PHIPA, individuals have a right of access to their record of personal health information, subject to some limited exceptions, for example, risk of harm to the individual or others, or if the information is subject to confidentiality requirements by law. The right of access is not limited to the health record itself. And I think this is really important because, traditionally, and based on, earlier case law, like the McInerney and McDonald case, when we looked at that, the health record and what the individual had a right of access to, it was the record that the health organization had, as well as any records that they might have received from other custodians, which formed the legal health record, in which individuals could did have a right of access. PHIPA makes it very clear, and the interpretation of the Information Privacy Commissioner makes it very clear that it extends to other records of personal health information. And there was one of the earlier PHIPA decisions, which has been cited in a number of other decisions, looked at the interaction between FIPPA and PHIPA when an organization may be subject to both. And PHIPA Decision 17 related to a request from an individual for the all of the records concerning the birth of his child, as well as all of the records relating to his wife. The child had died, so there were a number of complaints that were made. There were complaints to the professional colleges. There was litigation, and the request was for literally every piece of paper that had to deal with how the hospital interacted with these individuals. So the IPC said, it's really important when you're looking at these requests to consider the context to determine which piece of legislation applies, and does it relate to the provision of patient care, or is it something that's more general? And there's a requirement under the legislation where a record is not dedicated primarily to personal health information about the individual. So this would be most records other than the health record itself. There may still be a right of access to the portion of the record that can be reasonably severed from the record. So that means that many of the other types of documents that you use on a day-to-day basis If they have identifiable information about about an individual, there may be a right of access to that information. And that can be communication binders, incident reports, emails, staff assignments, internal reviews, your risk files. So really anything that is identifiable. Incident reports have traditionally been treated as administrative documents. They're created for the purpose of quality and risk management rather than individual patient care. But using this analysis and, a qualitative approach, where the information isn't dedicated primarily to the requester, in this case, an incident report, they still have a right of access to any personal health information that can be severed. Even if it does not contain personal health information, they may still have a right of access to that information under FIPPA. So here is the dilemma that everyone faces. How do you ensure a just culture which focuses on quality of care and transparency and allows individuals to come forward and speak about incidents and patient care issues in an open and forthright manner without exposing the organization and professionals to undue risk? Well, there are a number of different tools that you have in your toolbox for dealing with protecting quality and risk documentation. How they apply is going to depend on the type of organization that you are and what legislation applies. So for those that are subject to FIPPA, there is an exclusion under FIPPA for quality of care information, which is prepared for a designated quality of care committee under QCIPA. And it's very specific, and interestingly, I find that organizations are not always certain whether or not a quality of care review has been done under QCIPA or not. There shouldn't be any question at all. If you're doing a review under QCIPA, it needs to be very clear in your documentation that that's the purpose. Similarly, there is a quality of care exemption for hospitals. This was a late addition to FIPPA when it became applicable to hospitals in 2012. And it relates to confidential information that has been provided to or prepared by a hospital committee, and I underline hospital committee, to assess or evaluate the quality of care provided in the hospital for purposes of improving care and programs and services. So all of the criteria need to be met in order for a hospital to rely on this exemption, and there is limited application, so it only applies to hospitals. The requirement to have a committee to assess quality of care, usually is not difficult given the committee structure of hospitals. And there are many activities that are undertaken through a committee process at different levels. But ensuring that the information is flowing through those mechanisms is one of the key factors in order to rely on that exemption. The final area of that we can rely upon, and this is much broader than just under FIPA. This also applies when we're talking about disclosure of documents or production of documents in a lawsuit or proceeding, is legal privilege. And under FIPA, the test looks at records that are subject to solicitor and client privilege, as well as records prepared by or for counsel retained by a hospital for use in giving legal advice or in contemplation of or in use of litigation. So again, there's a special a portion of the exemption that applies to hospital counsel, whether it's internal or external retained by the hospital, and it applies to both solicitor and client and other litigation privilege. For litigation, just to give you a sense of what the general obligation is for production of documents in a civil lawsuit, for civil proceedings, you must disclose every document relevant to any matter and issue that is or has been in the possession, control, or power of a party. And the only exception to this is if it's subject to legal privilege. There are three types of legal privilege that we rely on. The first is solicitor and client. And this is intended to protect confidential communications between the client and the legal advisor. It allows counsel to provide legal advice. It also allows for investigations to be undertaken, and that information being provided to legal counsel for the purposes of providing legal advice. This is one of the strongest types of privilege because it's much easier to establish that privilege is in place. And then the second most common type of privilege is litigation privilege. And this type of privilege protects documents that are prepared in anticipation of litigation. The predominant purpose of the documentation must be for litigation. And then finally, the last kind of privilege is sometimes referred to as common law or case-by-case privilege. And this applies where there are policy reasons that create an incentive to keep communications privileged. It may apply to quality of care information. So there are four criteria that must be met. This is often called the Wigmore test. And it's really about confidentiality at the basis of this, that it must originate in confidence, that the communications won't be disclosed. That element of confidentiality has to be essential to the parties, and there has to be some public policy purpose or opinion of the community that this is something that must be protected and fostered. So this would be, in the case of quality of care, the ability to explore and review quality of care incidents, or even if it's not an incident, your practices to ensure that you're providing the best care possible. And then there's also this balancing that the injury caused by the disclosure of a communication must be greater than the benefit gained. The last tool that I wanted to talk about very briefly is the Quality of Care Information Protection Act, or QSIPA. Again, this only applies to certain health organizations, including hospitals, independent health facilities, labs, and long-term care homes. The intent of this legislation is to balance the need for facilities to engage in confidential discussions about errors and systemic issues and opportunities for quality improvement in healthcare. It uses the same definition of critical incident that's found in the Public Hospitals Act. You're not automatically able to rely on QSIPA. There are a number of things that have to be in place before you can use the legislation. First of all, the committee must be established as a designated quality of care committee under QSIPA in the case of a hospital, by the board. And terms of reference for the committee must be available to the public. There is the mandate of the committee is to perform quality of care functions. This is a defined term, but it really covers many different types of quality of care activities, and all aimed at improving or maintaining the quality of care. And it also includes reviews of critical incidents. Quality of care information is also a defined term, and it includes information that's collected or prepared by or for the Quality of Care Committee for the purpose of allowing the committee to carry out its functions. And the collected or prepared by or for is important because it allows the committee to carry out, to undertake certain activities itself, but it also allows the committee to request others, both internally or externally, to review an issue or an incident and report back. And it protects that information that's been prepared for that committee for those purposes. The one hallmark of QSIPA is there is a prohibition against quality of care information being disclosed except as permitted by the exceptions under the Act, and that includes disclosure in a proceeding. So there's almost an absolute protection for quality of care information, except for disclosure to the individual. But it can be problematic when the intent is to use the information developed through the quality of care review for other processes. Often a coroner, for example, will ask an organization to conduct a quality of care review and to report back the findings. This would not be permissible for any information that is created through QSIPA. There may be professional practice issues that arise, physician privileges. So there are some significant limitations to how that information can be used. And in some circumstances, it may make more sense to use solicitor and client privilege or another type of mechanism where ultimately you can waive that privilege. What is not quality of care information? So it does not include information in the patient record. It doesn't include the information that is required to be disclosed as part of a critical incident. It does not include facts contained in an incident report involving the provision of healthcare to the patient. So those are all, again, information that is to be communicated to the patient or the substitute decision maker as part of accountability and transparency. For critical incidents, it is also important to ensure that there's effective internal reporting and notification procedures so that individuals are coming forward and reporting any incidents that they see, and that there is the notifications that are taking place as required by the legislation within the organization are taking place. There are, as you know, there are requirements relating to disclosure to the patient of systemic steps taken. And the use of the Apology Act is something that's been entrenched in legislation, which allows an organization to provide an apology without it being construed as an admission of liability. And I think that's a very important part of the disclosure process where appropriate. So back to QSIPA and quality of care reviews or external reviews. Because of the restrictions with QSIPA, consider whether that is the process that you would like to follow. If that is available to you as an organization, or whether conducting the review under privilege is preferable, knowing that you can use that information in other processes and it's possible to waive that privilege. Not all reviews require the protection of for legal purposes, but where it's associated with risk, it's highly recommended that you take advantage of those tools. And finally, we're going to talk a little bit about risk management considerations and protection of documentation. So some really important things to be aware of in the context of legal proceedings or information requests. Privilege is not automatic, must be asserted. It protects communication, but not facts. So it allows you to, for example, express opinions in a document, but the facts relating to the situation itself are not protected. Privilege can also be waived or lost at times inadvertently. So it's really important to ensure that where you are asserting privilege over a document, that document is being tightly controlled, that it's not being shared widely within the organization, that it's not being provided to external parties, which would result in that privilege being waived. So this is all about taking a risk managed approach to ensure that the need to document is balanced against the potential that the information may be used in litigation. So some suggestions around incident reports. First of all, don't reference that incident report has been completed in the patient record. You want to make sure that incident reports are factual and objective. In describing the incident, avoid opinion, speculation, or editorial comments. You don't want staff talking about, the lack of staffing being, the reason for an incident, in the factual description of the incident report. And it seems straightforward, but it's something that organizations have to reinforce time and again. Aside from, the factual description that is in the component of the incident report, consider how to address the analysis or follow-up. If you are conducting an investigation and creating recommendations for follow-up, you may want to do that under a protected process if that situation is associated with risk, where the individual has indicated that they are unhappy or going to sue the organization, or even where there's just been a unexpected adverse outcome, and there's concerns about what the outcome may be from a legal liability perspective. In terms of a sort of larger framework within the organization, I recommend that you survey the quality and risk activities being undertaken both formally and informally and determine where they fall on the risk continuum. If you are relying on a privilege, legal privilege, or on QSIPA, or an exemption under FIPA, consider the structure of your overall risk and quality framework and any linkages between the organizations. So again, to rely on the quality of care exemption under FIPA, it must be confidential information that is provided for or prepared for a hospital committee. So having that committee structure will be one of the key requirements in order to be able to rely on that. Review the terms of reference for your committees, and ensure that there is language there that will allow you to rely on exemptions or privilege in the case that there's a challenge. Ensure that there's language there around confidentiality, whether minutes are going to be taken, whether they are going to be restricted to one central source of truth, and include that kind of language in the terms of reference, if that's the intention. Build language of the exemptions into your policies in terms of reference as well as your communications. So in your emails, they are producible in if there is a lawsuit or under a FIPA request. So indicate in the subject line that the information is confidential and the purpose for which you are communicating. Use templates or standardized communication and label information to ensure that protected documentation stays protected. You can't always be sure what type of institutional memory you'll have within the organization. And for many of these documents, the purpose for which you were documenting becomes really important if you are looking to rely on an exemption. So clearly having that marked in disclaimer language or in headers and footers will be important for those who come after you, as well as for you. Consider how you document, why you document, and where you document. This is a general comment really for everybody. When you are creating committee minutes, for example, think about the details of the discussion, may not necessarily need to be transcribed. But think about the action items. Think about whether there are any exemptions that may apply to certain parts of the committee minutes when you are creating them. So just to sort of wrap that up, when you are documenting, document for a purpose. Be deliberate and understand the criteria you need to meet when you are seeking to protect your documentation, identify and mark those documents, and support your practice through your policies in terms of reference. Always be professional and take a risk managed approach. So again, control access to documents to support confidentiality. And with this final thought, I'm going to wrap up and then open the floor to any questions. If you would not want something on the front page, don't put it in a record. That's the advice we give when documenting in patient records, but it's equally applicable in any other type of documentation as well. So I'm going to open the floor to questions. And if you have any questions, please put them in the chat box. If we don't get to all of the questions, I will undertake to follow up with you directly. One of the questions is, will the slides be available? And yes, they will be. We will be sending them after the presentation. Okay, well, in the absence of any other questions, and often these are really organization dependent. So we're very happy to talk offline about any issues or questions you may have. And thank you once again for attending our Back to Basics Coffee Talk. The next session will be with Lisa Spiegel, who will be speaking on credentialing in June, and you will be seeing an invite shortly for that presentation. Thank you again.